For me, data protection means not only sort of complying with the letter of the law, but also doing the right thing in the eyes of the consumer. It's all very well if one meets the minimum legal standard, but one has to think about a potential headline on the front of a broadsheet newspaper, and so one always has to consider the use cases. The mantra that we apply is that just because you can do something, it doesn't mean that you should, and the same applies to data protection law. Effectively, what data protection law does is strike a balance between the privacy interests of individuals and the right of businesses to use those people's data to run their business. And that's all that data protection law is designed to do. Now, that's easier said than done, and obviously at the moment there is an exercise underway in Brussels to restrike that balance. I only hope that they manage to do a good job. Marketers should care about the data protection regulation because it almost certainly is going to be coming into force in around about 2018, there or thereabouts. The proposed law, which is currently being negotiated in Brussels, most of it's already fixed and set in stone, but some important areas are still being discussed by the negotiators in Brussels. So it's very important, particularly that the marketing industry gets involved, and through trade organisations, through government institutions, and through MEPs, try their hardest to affect the outcome and lobby and affect the outcome of the data protection regulation negotiations. My fear is that the bar for data protection will be raised and make it harder for business to process data, with the potential effect of shutting down some of the digital economy, which would be a great shame. I think the most important aspect of the new data protection law for the one-to-one marketing sector is consent. It's absolutely vital that the level of consent is pitched correctly to strike the proper balance between the privacy interests of the consumer and also business use. My concern is that the bar will be raised too high in favour of privacy, contrary to the interests of business use. If, which is being discussed at the moment in Brussels, the consent bar is raised to the level of explicit consent, this will be very problematic for the marketing industry because it will mean a lot of third-party data sets which are currently being used will potentially be put out of commission. This will also play into the hands of the big companies with very large first-party logged-on data sets. That will obviously be bad for competition. So I think, to answer the question, the most important aspect at this stage in the negotiation of the regulation is to strike the correct balance in terms of the level of consent. It would be wrong, in my view, to sweep all personal data up into the same bucket and say that all types of personal data require explicit consent to use them. Sensitive data, such as health-related data, is a very different level of privacy intrusiveness compared to non-sensitive data, such as marketing demographic information. And again, there's a different, lower, in my view, level of privacy intrusiveness when it comes to data which has been de-identified, the sort of data that is used very often by the marketing industry, particularly in the digital economy. It would be a great shame if all these privacy-enhancing measures which companies have taken to ensure the privacy of consumers is protected will be swept aside in one move in the negotiations, raising the level of consent to one of explicit consent. That would, in my view, be a great shame, and as said, could have the potential effect of closing down large portions of the digital economy. What we're doing as a business is double-checking across the board to ensure that we are in full compliance with the current data protection law. That is very important, not just for my business, but for businesses in general, to audit themselves to ensure that they are meeting the current standards. That will stand them in very good stead when the new law comes into force, because as I said, the new law is very much based on the current law. In concrete steps, what I suggest to do is to take an inventory of the data assets that businesses hold and just double check those and record them properly, and then obviously check to make sure that there is proper compliance around those data sets. The next thing I would advise is to put in place a series of policies and procedures effectively demonstrating to the regulator that you have proper controls in place in your business which demonstrate compliance with the data protection law. A very good example of one of those procedures would be something called a privacy impact assessment. And this feeds into one of the future requirements of the data protection regulation, is that companies will need to build into their products and services privacy up front. It can't be an afterthought bolted on to the end of a product or service life cycle. It needs to be considered up front. So that's called privacy by design or privacy by default. So companies should start thinking very seriously about rolling out those sorts of processes and procedures. That will stand them in very good stead when the regulation comes into force in a couple of years or so. I would say at this stage to businesses out there not to panic because there is a lead-in time once the data protection law has been enacted of 2 years. And as I said, we don't know exactly where some of these important issues such as consent, profiling, legitimate interests will end up. So I would caution against carrying out a wholesale review of one's business based on a draft. There are a number of drafts out there, so it's difficult to know which one to comply with. Wait for the law to get enacted, and then you can do a proper consideration of how to get compliant with that. Also, it's probably a good idea to line up someone who has privacy law expertise and certainly knows how to implement those on the ground in industry. But the overall message would be, don't panic. If you do some of those things, you will stand yourselves in very good stead. My hope is that the regulation will have a positive effect on the UK economy. The current data protection law is more than 20 years old, so it was well time for it to be reviewed and brought up to date with the current technology, which had outpaced the current law. My fear, however, is, and as most of the data protection principles which currently exist will be pulled forward into the new data protection regulation, which is a good thing. Some of the red tape which currently exists in the current law will be removed, which is also a good thing. Unfortunately, a lot more red tape appears to be being added to the current law, which will create a big burden, a cost burden for business, which will be unfortunate. If some of these open issues such as consent, legitimate interests and profiling and long notices go in favour of turn more in favour of privacy and against industry, then that will obviously have a negative effect on industry, unfortunately. These are my main concerns, and I feel very passionately that the Brussels negotiators, they realise that this particular negotiation is too important to do political horse trading at this stage. They really have to take note of what the industry is saying, particularly the digital economy, and ensure that one of the success stories of the 21st century, which is the digital economy, is not stymied and closed down by a bad law. So I really implore the Brussels negotiators to take this point seriously and ensure that the proper balance is struck between privacy on the one hand and on the other side, use of data for business, so that the digital industry can continue to flourish.